Now we're gonna talk about Q&A.
Let's do a Q&A. The people they have questions for us, so let's do the Q&A.
Question and answers regarding probate.
Right.
Okay. I'm gonna ask you a question, and I want you to respond.
Let's do it.
Okay.
Let's do it.
We're gonna show them how bright you are.
You know, I was brightest in school.
It says, I have a will, because I remember a call came in like this.
Right.
I have a will. My mother left me everything.
Right.
The house, the car, everything. That's what she wrote in the will.
Right.
Okay. Is that all I need? Can I just move forward with my life?
Definitely not. You know, one thing is good that, you know, the person mother did, you know, have it in writing, but you still have to go through probate. You know, anytime you have a will and the will is present, you have to go through probate. The whole point of probate is proving the will. So if someone left the will, you have to go through probate. No will, you for sure have to go through probate. Right. The only way to avoid probate is by establishing a living trust.
Okay. Now, I want to add to that.
Okay, add to it. Yeah.
Imagine if mom said, you get the house. That's fine.
Right.
But right now, the house is in whose name?
Mom's name. Right.
Okay. So how are you going to get the house out of mom's name into your name?
Right.
It just doesn't happen.
It just doesn't happen.
You can't
Not through osmosis.
You can't just go to the courthouse and say, here's this piece of paper and my mama said it belongs to me.
Right.
That's not going to work. Now you see how important it is and understand why you're going through probate.
Right, right.
Because the courts have to say, yes, you are the beneficiary.
Right, right.
And yes, these assets are going to you.
Right.
You know, because the house was not put into a trust like
right.
you had made mention.
Right, right.
And so, yes, because you have a will doesn't mean that, you know, you can just do what you want to. No. Even with the car.
Right.
The car is still in your mother's name.
Right.
Okay? So you have to go get that cleared up with the Department of Motor Vehicles.
Right.
From wherever you live.
Right.
Okay?
Right.
Okay, you can't just be driving down the street, you get a ticket, and they send the tickets to mom. That ain't gonna work. You know?
Even though she won't have to pay at this point.
Yeah. But the bottom line is,
right.
In order to get the assets into the proper name, okay, it must be probated.
It has to be.
And then you have to get the proper paperwork to show that you're the owner of the property.
Right.
Now, if mom's left the house and it wasn't paid off and there's a lien, you can't even talk to the lender.
Right.
The lender is not going to talk to you until you have the proper paperwork to show that you're the owner.
Right.
And because you have a piece of paper that's left from mom that may have been signed by her, this lender doesn't know who your mama is. She don't know what her wishes are.
Her handwriting.
They don't know you. They may. I mean, they could probably look at the handwriting from the loan application and stuff, but they don't know. They don't know who her children are.
Right.
They've never met you.
Right.
They don't have your ID. None of that stuff.
Right.
You know. So you have to go to court to say that you do have the authority to operate and control the estate. Right. To administer the estate.
For sure.
Right. And then if you have a will, what would they be?
What do you mean?
You know, are they going to be an administrator, an executor?
Okay, yeah. So with the will, you know, if a will is present, that person will be known as the executor.
Right.
And if they're of the estate, and then if no will was present, that person would be recognized as the administrator of the estate.
Right. So that's a good question that had come in.
Right.
Another question is, it says, what does probate mean? Why don't you explain to them, what is probate?
So probate is basically the legal term of for the gathering of the assets of a deceased person to pay their debts and distribute the rest of the balance to the beneficiaries or their heirs. Okay. Heirs or beneficiaries.
Right. Now, if there is a will, who's making that determination?
The executor.
Okay. But the decedent still left their wishes in the will. Right. And the executor is carrying out what the decedent may have wanted.
Right.
They did put something in writing.
They put something in writing. They left some instructions behind as to what they want done with their estate. Right. So that's why someone would be appointed as the executor.
Right. Now, if there was no will, and you're the administrator, who's making those decisions? I mean,
the administrator is, but the state is appointing someone to make those decisions.
Right. According to what?
According to state laws.
Right. To the laws of the land.
To the laws of the land.
Okay, so now it says, what is the purpose of the estate administrator? What's the purpose? I think you just said it.
Right, yeah, just to administer the estate, making sure that everything is done properly and fairly.
Right.
You know, it's duties and liabilities that a personal representative has to carry out, and a personal representative is just a broad term for executor or administrator, that they have to carry out, and for the benefits of the heirs and the beneficiaries to the decedent's estate.
Right. So if you want to learn more about that, we did talk about that in the different phases of probate.
Right.
You can watch another show that we kind of put together, education, to kind of educate you on that process.
Right.
So the other question that has come up, what's the difference between a testate or intestate?
Intestate. So those are two important terms in probate. So testate is a term for someone who died with the will. When you hear the term intestate, that means someone passed without a will.
Okay. Intestate.
Intestate, no will. Testate, will.
With a will.
Right. So it's the same play off of the executor and administrator. You know, executor, intestate, meaning the decedent left a will. Intestate, and administrator, that means that there was no will present.
Okay. That's good to know. You know, you gotta, understand the lingo.
Right.
You
definitely have to understand the lingo.
So, based on you saying that, testate and intestate, now, the question is executor and administrator. What's the difference between the two and how they occur? We've been talking about it, but just clearly tell what an executor is versus an administrator. Right.
I mean, just what we said earlier, with the executor, there was a will present, and so the decedent, they laid out their wishes, and they appointed someone to carry out those wishes, for the benefits of their heirs. And then for administrator, no will, and so the state has to appoint someone to carry out the decedent's estate to make sure that the heirs receive their proper inheritance.
So remember, the main thing with the administrator is going to be according to the laws of the land.
Right.
Okay. If you're administrating the estate.
Right.
If you're the executor, you're carrying out the wills of the decedent because they did put something in writing.
Right.
But you have to go through probate because they still have to validate the will. Like
they have to prove that will.
Right. So here's another question that commonly asked.
Right.
Can property be sold in probate?
Right. I think that's the best question. And of course, you definitely can. During the administration phase, just as we brought up earlier, the 3 phases of probate. During the administration phase is when the personal representative could take action to sell the home. If that's something that they wanted to do. Okay. So you could definitely sell the home as you're going through probate.
Right. So you don't have to wait until probate is over with. You don't have to wait no specific time. Just once the person is appointed as the administrator or the executor, you actually and you find out what authority you have. Right. You can go ahead and list the property, sell the asset in order to liquidate and get the monies to pay off the debt. Right. And then send the net proceeds over to a special account, which will eventually be used to cash out the beneficiaries. Right.
And just as you just mentioned, as far as, selling the property, once you receive the letters, once you have the letters and the probate has been ordered and you receive the letters, that's when you can fully move ahead and sell the property if that is what you and the heirs want to do. Right.
Okay. And then the last question that we hear a lot of, it says, if no will exists, okay, it talks about how would the property be distributed? Right. So it's kind of like a little process there.
It is a process.
Will,
right. No will.
How's the property going to be distributed?
I mean, it really goes according to your state laws, the intestacy laws of your state. I know in California, spouses, they have the top priority. No one comes before the spouse. Then if no spouse or if the decedent never married, it'll go to the children. And that goes from the children, the grandchildren, to the great grandchildren, down to the parents.
Okay. Well, and there's a twofold to that answer. He gave you the lineage.
Right. The intestacy laws.
The intestacy laws. In what order you may have priority. Right. But the answer to that question is, if there's no will, okay. You first have to become appointed as an administrator. Right. And based on what we just shared with you, the lineage and the order of priority.
The order of priority.
That person who's appointed as the administrator can go ahead and liquidate the property. Okay, once they're appointed.
Right.
And then distribute the proceeds after the probate. I should say just about right before it closed.
Right before. Right.
Once the proceeds have been distributed, then the probate is closed.
It's closed.
Yeah.
And this is a done deal.
Yeah.
But yeah, those are typically the questions that we get asked.
Can you think of anything else? I'm just trying.
I can't think of anything else on the top of my head right now. I think those are pretty much the most typical one, unless you have some.
I think those are pretty the most common questions that come in that I can think of. Anyway, if you need more information, if you want more questions answered, if you want to share your situation and maybe get some direction, get in contact with us. Okay, feel free to call us so we can give you some direction and maybe refer you to some great attorneys. Great attorneys that we know. Okay. If you like what is being shared on this station, on this channel, please subscribe so that we can send you more information, let you know when more tapings are coming out. We're going to share our experiences because we have a lot of interesting cases to share. And on the channel, we're going to upload some conversations we've had about situations we've been in. And so you can watch that and learn from that as well. Okay. And give us a thumb up.
Yeah. Like, share, subscribe, comment. And then also if you want to reach us, you could give us a call at 1-800-720-9788. And we'll talk to you guys soon.
Thanks.